Welcome to SovCit Legal Encounters. All right, today we're going to be checking out the Sachs case again, and this hearing is very informative. There's questions that you've asked about this case that I really couldn't answer. Now you're going to get all the information in this particular hearing. And also, I want to give a shout out to our Nevada judges. Their link is in the description. Check out their YouTube channel. They do good work, and I think you'll enjoy some of the cases there. So I'm sure when you check out this hearing, you're going to want to listen to the entire thing. It's really good, and I learned a lot from it, and I'm sure you will too. Let's go.
Dina Renetti for the state.
Charles Goodwin, 14879 for Mr. Sachs. I cannot determine if he is online.
It looks like he is, Your Honor. And this is Chet with 4747 for Zhang.
Thank you. All right. This is the state's motion to strike the expert witness, I believe it's Dr. Richard Samelka is how you pronounce his last name.
That's correct, Your Honor.
All right. And the defense has filed an opposition. The court has read and reviewed both the motion and the opposition. And I looked very specifically at the Davis versus McKesson case that was cited by the state. I will say just at the outset, that is a 2019 case. And I think that there is at least an argument to be made that when we're talking about an evolving medical field, that a lot can change in 6 years. Neither side addressed something that I think is important that I would like both sides to consider, which is even if the court, because obviously the court acts as a gatekeeper whenever we're talking about expert testimony and whether or not it's going to be admitted or not. And the burden is on the party that is attempting to admit that testimony to establish that it is admissible under our hallmark standards. Neither side addressed the fact that even if the court were to find that Dr. Samelka was qualified and that his opinions were the product of reliable methodology and met the standards under hallmark, that it could still be inadmissible on the basis of confusion of the issues or confusion of the issues under Rule 405. So that I'm going to just tell you guys some of the questions that I looked at when I was, and then I'll certainly give both sides opportunity to argue the motion, the opposition, and anything that I've asked questions on. So that was not addressed. The other issue that I thought was important was when we're talking about whether or not Dr. Samelka's opinions are based on reliable methodology, all he's done is looked at the medical records. And from the cases that I read, and specifically the Davis versus McKesson Corporation case, I think was, at least in some respects, very enlightening because it talked about the difference between GDD and gadolinium toxicity. It's a hard word to pronounce, and I always want to add an extra M to it. They talk about the difference between renal impairment, non-renal impairment, NSF, and the different continuum of symptoms, and when they're addressing that in that case. And to the extent that I don't have any information contained within the expert report, and I did read Dr. Samelka's report, that the child that is in this case either had renal impairment or even suffered from the same symptoms that are talked about as a result of gadolinium toxicity and or GDD. I don't know that his testimony would assist the trier of fact, because if in fact none of the symptoms that he has, that the child had, can be related to gadolinium toxicity or GDD, then how is that scientific that would assist the trier of fact?
As you can see, the judge is looking at things very carefully so she can figure out if this expert is really needed in this case.
So that was another issue that I saw. So I broke it down a little bit more, but with the renal failure and the renal challenges and or symptoms not associated, and a reliable basis for him to conclude that there was in fact, and nobody has, and that's the last point, nobody's actually diagnosed this child with GDD or gadolinium toxicity. And to the extent that he hasn't been diagnosed with that, I don't know, and your doctor has not diagnosed him with that. Your doctor has not examined him. I understand the argument that that potentially could go to cross-examination and wait. But my concern here, and that's why I brought it up initially, is are we creating a situation where we are having a trial within a trial on medical causation of a disease that this child has not even been diagnosed with, which could potentially confuse the jury and therefore be inadmissible under that standard?
Now, that's definitely a new piece of information because I didn't know that he wasn't diagnosed with the issue that they're talking about.
So those were the issues that I saw that I wanted you all to address before I made a decision as to whether or not we were going to need an evidentiary hearing. Because in looking at his CV, it's very clear to me, originally when I read the motion, it was unclear to me as to whether or not, yes, he's a radiologist, and yes, he's qualified as an expert radiologist, but we're not talking about just radiology. We're talking about a very specific disease that's related to a contrast dye that is used in MRIs. So to the extent that we are talking about that, I wasn't entirely sure based on the original motion that he had actually been peer reviewed or had treatises or articles or done studies on that issue. Looking at his CV, it's very clear that he has. In fact, even in the Davis versus McKesson Corporation case, they actually cite to his research. So I think that to the extent that he is qualified to talk about it, I would say that he is qualified to talk about it. What my concern is that whether or not we are bridging the gap between his ability to talk about it and whether or not that, in fact, is something that this child actually has. Because if it's not something that he actually has, and he doesn't have renal failure, and he doesn't have the symptoms that are associated with gadolinium toxicity and or GDD, because based on what I could see, I didn't see that his symptoms necessarily coincided with what was cited as potential symptoms on the continuum that was listed in Davis versus McKesson. And that's why I said at the outset, yes, but this is a 6-year-old case, that might have changed. So to the extent that I would need an evidentiary hearing, I think that that would be the focus of my evidentiary hearing. And I honestly don't know, as we sit here right now, if it doesn't make some sense to have this child go to almost an IME and have him tested to see whether or not this is even a potentiality, because all we're looking at right now, and all your expert did look at, Mr. Goodwin, was the medical records.
Now, I didn't know a lot about that disease, but I did look it up, and the judge just covered basically explaining everything about it. And it would make sense to give the child an examination since the child was never diagnosed with it, and then they can put 2 and 2 together and figure out what the exact issue is and how they need to move forward.
He hasn't examined him. He certainly hasn't examined him now. And I don't know, I guess that brings up another question. once you have GDD, does it go away? Could he have had GDD then? And now 7 years later, he doesn't? So those are all the questions that were raised in my mind as I was reading the cases. And with that, I will allow both sides to argue and potentially answer those questions and see where we go from here. It's your motion, Ms. Bernetti, so you get to argue it.
May appreciate, Your Honor, because I think that's kind of some of my focus as well. I mean, I do believe on its face, is Dr. Samelka a qualified expert in radiology? Absolutely. I mean, yes, absolutely. It's this underlying diagnosis of gadolinium disposition disease. And that's what we're talking about. And from what I gathered from my expert and from all of the literature, both from the federal government and from case law, is that this disease is not recognized in the medical community. And based upon that, it doesn't assist the trier of fact because it doesn't qualify under the hallmark factors. And so that's why I do believe, though, I don't think my motion's sufficient enough. And I do think the Nevada Supreme Court would want an evidentiary hearing so that their expert and my expert can say on the record under oath the exact status of medical science as it is here in 2025. Because I do agree with you, things can change fairly rapidly in the medical community. I'll say that from speaking with my experts, we're still at the status quo, but obviously I think the court needs to hear that testimony to that effect.
Well, and Mr. Goodwin noted in his opposition that it's now actually recognized as an ICD-10 code. So to the extent that it's recognized as a diagnosis, I don't know that that necessarily saves you, Mr. Goodwin, because I do think that it's I don't know. I'll say this. I don't know whether or not it's recognized as a diagnosis for people that have renal insufficiency, or if it's recognized as a diagnosis just in general for people that don't have renal insufficiency.
Out of curiosity, I went out and checked to see if I could see that ICD code out there. The ICD code is out there for the disease, but it's just a general description. I didn't find anything that had anything to do with renal or things that they named in the court. And I'm not a medical professional, but I just took a look to see if I could find something so that I could share it with you here.
Don't know that. So unless there's anything to add, I mean, the state is flat out admitting that they think we need an evidentiary hearing. I don't know if you're on board with that, if you think that there's something else that needs to be done, but I am concerned I'm concerned in both respects. I'm concerned with a couple of things. I'm concerned about not allowing the defense to be able to present this, because I think that potentially if we go through a trial and it's not presented, I think that it is absolutely fodder for an appellate issue. And if the Supreme Court said, no, I should have let it in, then I think that, and I don't like to make decisions based on what could potentially happen at the Supreme Court level, but they are definitely things that you look at in the back of your mind. But I also am concerned about the aspect of having a trial within a trial and confusing the jury on the medical issues, because I think ultimately this almost comes down as an affirmative defense on your side. Would you agree with me on that, Mr. Goodwin? Because it's the state burden to prove beyond a reasonable doubt the child abuse, neglect, and endangerment. But then this is your theory of the case coming in to say, no, it wasn't child abuse, neglect, or endangerment. This is what happened. Wouldn't that be your burden to prove?
Brief course indulgence while I think about it.
Sure, absolutely.
And maybe we can work this out together, Your Honor, because I'm trying to run it through my head, but sometimes if I get too many threads, I start losing them. So let me try and think about how this is. I think that the statute for child abuse and neglect and endangerment would allow him to be convicted regardless of whether there is any harm to the child. I think that that's clear from the statute. So the fact that he took certain actions in the hospital, regardless of whether or not anything else happened afterwards, whether or not he had the seizures or whether or not his condition got worse, he could still be convicted for the actions in the criminal complaint. I think that that's a fair statement, number one, which leads me to number two. The issue with why we have our expert is explicitly because the harm to the child is consistently brought up throughout the case, throughout the police report, and throughout the case. So I think that if you say it's confusing the issues, I think that there is some validity to that, but I think that we necessarily have to confuse the issues in this instance because the state of the child is 100% going to be brought up into court. Now, if the state would like to stipulate, and I don't think they ever would, and I don't blame them, I wouldn't stipulate to it either. If the state would like to stipulate that we're not going to talk about any of the harms to the child, we're going to keep it directly on whether or not this could have and what the potential would be, then I think that we can excuse Dr. Semelka as an expert at that point. Because then we don't have to push back on the natural harm that occurred or that the state is alleging occurred as the result of these actions. So if the state is going to talk about, look at the state that he was in and all these other types of things as a result of the actions that Mr. Sachs is taking, then we need Dr. Semelka to say, no, hold on, that did not result from the actions Mr. Sachs did. It resulted from the contrast that he was given while he was at the hospital. Now, going next, you see where my thought line is going now to the affirmative defense. That raises an interesting question, because if we're saying an affirmative defense, I don't know if it would go to an affirmative defense, because then we would be saying, yes, he was harmed and it was my fault, but here's why I did it. I think that's how we look at affirmative defenses. Affirmative defenses generally are saying we are admitting that something occurred in self-defense. It could be that you killed someone in necessity. Yes, I broke into the house, but here's why. So when we're saying gadolinium disposition disease, I don't know how that burden shift would look, because now it's not like we're negating a mens rea or other thing like that.
No, but it's your burden to prove that it wasn't anything that the defendant did to this child, that it was as a result of the gadolinium.
May I interject?
Okay.
Yeah.
I feel like we're trying to figure this out. So if you want to interject, please feel free.
I don't believe they have a burden. So I believe what their expert's going to say is, because there's 5 theories of child abuse, we're going under a negligent treatment, maltreatment theory.
Okay.
That this child was under proper care, control, and supervision based upon the steps that the defendants took. I believe it's their contention at trial of like, no, it was proper care, control, and supervision because we were using alternative medicines.
Mhm.
We were in our right to. It didn't cause our child harm. And the reason why actually he was harmed is because of Western medicine.
Mhm.
And so we believed, as a rational caregiver, we were giving proper care, control, or supervision. So the state hasn't met its burden.
That I would agree with. I would agree with that statement right there. I was thinking about all the theories that it can go under. I apologize.
I would agree with that as well. However, it's still, if the state's burden is to prove that it wasn't proper care and it was negligent care and or abusive care or endangered the child in some respect, doesn't the burden then become on the defense after that point to say, no, we didn't do anything wrong?
No, I don't believe, because affirmative defense requires some type of burden of proof to negate it. I think they just need to enough to have at least one juror say, I know what, I have reasonable doubt whether or not this was proper care, control, or supervision. I think
Okay.
that's where.
Okay, so it's just coming in to negate the reasonable doubt of the state's burden.
That's correct.
Correct.
Okay.
Yeah. So I would not classify what they're doing as an affirmative defense.
Okay, all right.
Your Honor,
Yes,
if I may, really, this is going to go to the testimony that just what you said, but the testimony that the state puts on and who they put on the stand.
wait, what?
Someone's got to come and back up the state and say this was just not reasonable, right?
Right.
And that would I would argue just in a regular med mal case, this is just going to be another opinion about that. So I would disagree that it's an affirmative burden. I'm sorry.
That's fine. That's why we were working through it, because as I was thinking about it, I was like, well, it's not up to the state to prove that it was or wasn't gadolinium toxicity or that he has GDD. It would be, I was trying to figure out why this is coming in this instance, and that makes a little bit more sense to me now. All right.
Would you like me to move to the other issues? Your
Yes, please.
Honor? Okay. So that I think, does the court still want to hear confusion of the issues? I think that was addressed in that one. I think that the issue there is that, whether or not he was. So I think that it's not too much of the confusion of the issues, it's just negating one of the elements.
Gotcha.
So the renal impairment, I just want to talk about that. the renal impairment, in my opinion, gives you the stronger position in gadolinium, and that one seems to be sort of accepted mainstream a lot more.
Right.
But what we're saying is that it's not just people with renal impairment who suffer from gadolinium deposition disease. Now, I would have provided a lot more studies by Dr. Semelka, but I did not want to seem like I was self-aggrandizing. But I'm sure if the court took a look, there are a ton of studies on gadolinium deposition disease that they're all written and handled by Dr. Semelka. So I think that he does have relevant things here to speak to it. And when we're looking at when we're looking at that specific issue on whether or not this is someone who should come in, I don't think that they've met their burden in that instance, because what he's coming in to speak to is all of those that he's seen. And based on the medical reports that he's looking at, he sees that this is likely what happened in this case, that it matches other cases and other diagnoses that he has. Now, I understand the court's concern about the fact that he has not been tested, but I would like to point out something that's very important.
Sure.
Mr. Sachs, on all of his consent things, told them, do not use this type of contrast. It's in the medical records. He told them, I don't want you to use this. I think it's going to be poisonous to the child. They were on notice at that point. Don't use this for that. They used it anyway. And in fact, in the grand jury, I believe they testified they don't need the consent of the parents on whether or not they have to use that. And they went along with it. Not once when they had him in their custody and control, did they test him for that. And that was one of the biggest issues that Mr. Sachs was consistently bringing up in the hospital. Now CPS got involved, and the child is not in Mr. Sachs's, according to the Nevada thing, it's not in his care or control, because CPS removed the child from him and the wife's custody. So he could not have gotten the child tested shortly after that. What he did do, which would go to this, and this is what makes it kind of interesting, is that he did what he thought would flush the poison from his son's system. And that's where the case kind of goes into there. So I don't think that we can place that burden on Mr. Sachs to say, hey, you need to go get the child tested to see how that, and even if at that point, I believe the burden at that point maybe should have been on the hospital to take him a little more seriously when he was saying about the contrast and everything else like that.
Now, this attorney is making some really good points. And I know a lot of you have been in the comments asking what's going on. I tried to give you the best answer that I could, because I didn't get the first amount of hearings way before I started this series. So now there's a whole lot of things that's coming out. And I want to hear from you in the comments. What do you think about what's going on right now regarding what the attorney is saying, even with Mr. Sachs, where, okay, he couldn't get the child tested. So now we have more things for us as viewers to look at, and we can discuss it in the comments, what you think about this situation and how it's going.
So that's what the issue with that argument is. And I don't know if we can, at this point, compel the child to get a test or anything like that. I don't think that, Dina's shaking her head. I don't think we can do that. And I don't know if it would, and I am not aware, Your Honor, if it would still show effects of gadolinium poisoning. So that's the thing. That's the issue with that. So I think that
I think that that's a question for the expert.
Correct.
I think that that's a question. I mean, once you have it, does it go away? What are the symptoms because from what I could read and what I saw and I'm going purely off of that Davis versus McCusson case, because there were 3 different people that had a whole host of symptoms that they laid out. And I was not seeing, based on that case, and I did read the expert report. I didn't see that his testimony in that expert report is de minimis on whether or not this actually was gadolinium toxicity or GDD. And once you have it, I don't know if it goes away. I don't know whether or not the symptoms that are in this case are the same sort of symptoms that are related to GDD or gadolinium toxicity. And so those are questions that I think would probably properly be left for the expert.
I agree, Your Honor, and I think that it can be done on cross-examination. I mean, those are items there because that goes to not relevance, but weight, in my opinion.
But the problem is if we do that in front of a jury, you're potentially creating confusion of the issues and we're doing a mini trial in front of the jury. I would feel much more comfortable doing a small evidentiary hearing on those issues as to whether or not this is based on whether or not you can bridge the gap between what happened in this case and the scientific evidence of gadolinium toxicity or gadolinium deposition disease. And if you can't bridge that gap, then I don't know how this evidence and his testimony becomes relevant and admissible in this case. So that's my concern.
Sure. And what I would say to that is if we can't bridge that gap, Mr. Sachs is guilty. And that's why I think it goes to weight, not admissibility. I think whether or not gadolinium, and I understand what the court is saying, I would say what my position would be that if he comes up and then there's a lot of cross, he doesn't have this symptom, he doesn't have this symptom, he doesn't have this symptom, you didn't see this, you didn't see that, you didn't see this. That is what a lot of what testimony comes from. I've crossed experts from the state on DNA and other things like that. Now, if the court wants to question whether or not this is a real thing, that's the one. But I would argue that the ship has sort of sailed on whether or not we can get any diagnosis on gadolinium deposition for the child based on the fact that it was never done at the time. And according to CPS, Mr. Sachs does not have care or control of the child.
But I don't know that it has. That's my point, Mr. Goodwin, does it go away? I don't know that it does. And that's the issue that I have. So once you have it, if you still have it, that's something that could potentially be tested. And the issue of whether or not the symptoms that he had are in fact related to GDD or gadolinium toxicity that's something that could be looked at in the medical records that was not fleshed out sufficiently, at least for me, in his expert report. And I think that you are creating an issue with simply allowing him to be put on the stand because you are potentially creating reasonable doubt with something that should not be potentially admitted and be put in front of the jury, because the court has to function as the gatekeeper. And if it doesn't meet the standards under Hallmark, then it doesn't meet the standards under Hallmark. So those are my concerns, because if it doesn't meet the standards and I allow it in, then that would be improper.
I understand, Jared, but I think that what we're speaking at, and maybe we're talking to two different things here.
Sure.
I think that Hallmark goes to whether or not the science that he says is legitimate. And then that's the one. That's the first part.
That's the first part, but that's not the full test.
Then the other part, so the court is looking at whether or not it's going to go to that one section of whether or not he had actual facts on the circumstances.
Reliable, yeah, whether or not his opinions are based on speculation and conjecture as to whether or not that is actually what happened in this case. Because if it's based on speculation and conjecture, and he doesn't tie his opinions that the actual facts in this case support gadolinium toxicity and or gadolinium deposition disease, then it's not reliable. And his methodology is not reliable, and therefore it doesn't come in under.
There's definitely a lot of decisions that need to be made. And the good thing is that they're trying to brainstorm all of this out so that they can get this case and this trial moving forward.
I apologize, John, I'm thinking.
You're fine.
Sorry, I take brief pauses because I want to make sure I understand everything before I
You're
answer.
fine. Yeah, we're not challenging the first two prongs. We're not challenging whether or not he's qualified to testify, because he is an expert in radiology and he has written significant treatises on this issue. Whether or not it is accepted or not, I would agree with you. I think that goes to weight. What I'm focusing on here is whether or not his opinions are tied to the actual facts in this case.
Well, I would go one step back. I agree with you about the relevancy for this particular case, but I still go back to whether or not there is, under the hallmark, you being the gatekeeper, whether we can say gadolinium causes this list of symptoms that Dr. Samelka has categorized as gadolinium toxicity. And I believe that has not been proven by medical science, not even to then jump into whether or not this child had.
Well, I don't think that Hallmark requires, I think Daubert is a different standard than Hallmark, and I don't think that Hallmark requires that it be proven.
Well, I would go to the factors of regarding the knowledge and whether or not that host of or litany of symptoms qualifies for gadolinium disposition disorder.
But that
Right.
goes to what I just said. That goes to whether or not his facts and opinions are based on speculation and conjecture. Because if they're based on speculation and conjecture, as it applies to this case, then it's not admissible.
No, I agree, but I also believe that gadolinium disposition disorder is based upon assumption and generalization and conjecture at this point in the state of the medical evidence. And that's what I think both Dr. Samelka can testify to, and then my doctor can testify regarding that. The status of the of medical science as it is today regarding the supposed gadolinium toxicity.
But I don't have that in front of me.
And that's why I'm just asking for the evidentiary hearing.
And I agree with you.
Your Honor, I think that then, and just to be clear, I'm in disagreement with the state. I don't think prong 2, I think the ICD-10 code is dispositive of that. The fact that they are recognizing it as a diagnosis.
But that's what you are saying. I don't have proof of that.
You don't have proof of the, was it not attached as the exhibit, Your Honor? I thought I attached as an exhibit the CDC's manual where they recognize GDD and placed it as an ICD-10 code.
Find it in here. What you did is you gave me a link. You didn't attach it as an
I
exhibit.
apologize, Your Honor. That's right. It was very lengthy. I think it was about 72 pages.
Right.
Because it was a whole thing where the CDC was placing a whole bunch of.
Yeah, and
details.
unfortunately, I can't go into links. Our computers don't allow us to do that. So
That is good to know. I'm sorry, Your Honor, I did not know that. So I can provide a copy of that to the court if the court would like to look at it. But I think that based on what the court's saying, then yes, there should be further evidentiary hearing on prong 3. I think
yeah,
prong 3.
because my issue also is I don't know without looking at, and that was one of the things that I brought up before, was when just because it's got an ICD code attached to it and is a diagnosis, is that only in people with renal insufficiency? Or is that in people that don't have renal insufficiency? Because if it's only in people that have renal insufficiency, then we have an issue with the fact that this child didn't have renal insufficiency. And we go back to the drawing board of can Dr. Samelka's opinion be applied to the facts in this particular case? So those are the issues that I saw, and I don't know that as I'm sitting here right now.
I believe that's a correct statement, what the court just said on the renal sufficiency, and I can't speak to that right now.
Okay.
So then, yes, if it's that issue, then I think that does warrant, because I think that you're right, that if it's only for renal insufficiency, then I think we have an issue on that. I don't think we still lose it on that. I think we've still got play, but I do think it changes the game entirely.
So, and what I want to make sure is that whatever, to use your phrase, whatever game is going to get played, that we're all playing from the same playing field with the same set of rules.
Understood, Your Honor.
And so I think that it's appropriate in this particular instance, based on the briefing that the court has received, and the exhibits, for the court to have an evidentiary hearing on the issues that were raised by the court. And I think that now gets into, when are we going to do that?
We did discuss, and I remember, Rem was kind enough, but this was a long time ago, your schedule. Would August 21st still work for the court?
My only caveat, Your Honor, is that they were looking for an afternoon set. I was assuming in my head that it was going to be morning. So
We're gonna be in trial, so I would have to do the morning.
Morning.
I would have to do, what day is that?
It's a Thursday, right now we have.
Yeah, that's not gonna work.
Okay.
Yeah, that's.
The 21st doesn't work.
Okay.
Does-
I would
Your Honor-
prefer to do a Tuesday or a Friday, because those are the days that I give full hearing days for my trials. But I can always start the trial a little bit later. Mondays and Wednesdays are my criminal calendar, and I give the afternoons for trial on those days. So I would prefer a Tuesday or a Friday.
My doctor can, we can do 22nd, November 5th.
November.
August, sorry, I apologize, August 22nd. I can do September 5th.
I cannot do the 5th. I'm sorry.
Your Honor, and I don't mean to cut you out, Travis, but you may not be needed for the evidentiary hearing based on the fact that there was no joint or anything. And of course, if you'd like to, or your client would like to observe, I don't think it's an issue, but I think it's not.
I don't want to gum up the works. Thank you.
And I hope you don't take that in any mean way, Travis.
No, that's a recurring theme in my life, Charles. Thank you.
Okay, so the 22nd, the 5th, and was there another date?
The 12th, those are all the Fridays.
Your Honor, I think the 5th is what I could do as well.
And you guys are supposed to start trial on the 16th. So I'm gonna literally have to make a decision that day as to whether or not this is coming in or not.
And I apologize, Your Honor. I could do potentially earlier I could do 15th,
I could do, what?
potentially the 15th.
Of August?
Oh, I'm gone.
Okay.
My kid's getting purple.
Okay, so I think. Can you do the 22nd or no?
No, Your Honor, I could not do the 22nd. I
Let's do
apologize.
September the 5th then. What about the 29th? All right,
I see no reason why the 29th would not work for
my
myself.
only concern, and I didn't talk to my doctors, the 29th, the weekend of Labor Day weekend. So I'm thinking doctors on both sides, that might be a little
all right, let's do
problematic.
September the 5th.
And I'm emailing my expert right now to let him know. So if there's any concerns, I'll know right away.
That's fine, we'll move that. This one's going to trial. I've got to get this done.
Right. So what time? Yeah. Because we have it's Shlomo James coming.
I don't know.
Okay. What time do you want to do it? Do you want to just? So September 5th at 9 AM.
If it helps either side from a go forward basis, obviously I haven't made an ultimate decision one way or the other, but my inclination as it stands right now would probably err on the side of allowing Dr. Smolka to testify as opposed to not. But like I said, I haven't made an ultimate decision yet. I definitely want to hear from Dr. Smolka on the issues that the court has raised. But
And I'll have the state's expert as well.
all right. I will see everybody here. We're gonna do 9 AM on September the 5th.
And Your Honor, the court is okay with AV
For both.
for both.
Yeah.
Thank you,
Yeah,
Your Honor.
thank you.
Yeah, I'm not gonna make them come here.
Perfect. Thank you, Your Honor.
Perfect.
All right. See you all at 9 AM on September the 5th.
Thank you, Your
Thank
Honor.
you, Judge.
Well, I think this video gave great perspective into the case. Now, those of you who had questions know what's going on. And now we're going to move forward and see how things get prepared for trial. So I'll bring the next video to you. Thanks for watching. Give it a thumbs up if you like it. And I'll see you around on the next one.